Hello, I'm Mashood Iqbal. I'm a barrister at London V Chambers. Today I will talk about procedure of appeals in the Upper Tribunal Immigration and Asylum Chamber. The process starts when the first year tribunal decides your appeal and promulgates its determination. There is no automatic right of appeal against the determination of the first year tribunal. Therefore, either party, that can be yourself or the Home Office, has to seek permission to appeal to the Upper Tribunal. There are two chances to make an application seeking permission to appeal. First chance, you have to apply to the first year tribunal seeking permission to appeal. You have to fill in an application form, draft grounds of appeal, and attach with that a copy of the first year's determination and also a decision by the Home Office. The limitation period to apply for this permission is 14 days if you are in the United Kingdom. And if you're outside the United Kingdom, then the limitation period is 28 days. It is important to remember that insofar as limitation in the first year is concerned, the limitation period starts from the day when you receive the determination by the first year tribunal. If the first year tribunal grants you permission to appeal, then you have to go to the Upper Tribunal for an appeal hearing. But if the first year tribunal refuses to grant you permission to appeal, then for the second chance, you have to apply directly to the Upper Tribunal. You have to complete an application form, draft grounds of appeal, attach the decision by the first year tribunal refusing to grant permission to appeal, the determination of the first year tribunal, and also decision by the Home Office. You have to send the application form to the specified address that is stated on the application form. Now, you must remember the limitation period for applying to the Upper Tribunal is although 14 days when you're in the UK, but the limitation period starts from the day when the decision by the first year tribunal refusing permission to appeal was sent. And if you're outside the United Kingdom, the limitation period is 1 month and it starts from the day when the first year's refusal to grant permission was sent. Now, if the Upper Tribunal grants you permission, then you have to go to the Upper Tribunal to attend the appeal hearing. Now, for your assistance, we have prepared a presentation that explains the procedure for your assistance. Once you attend the appeal hearing before the Upper Tribunal, the procedure is as follows. The Upper Tribunal appeal hearing is divided into two parts. First part is called error of law stage. In that, you don't have to give evidence, but your legal representative, that may be your barrister or solicitor, or yourself if you're appearing in person, have to make legal representations to persuade the judge that there is a material error of law in the determination of the first year tribunal. The Home Office will be represented by their senior presenting officer. If the Upper Tribunal decides that there is no material error of law in the first year's determination, then the Upper Tribunal will dismiss your appeal and that will be the end of the matter. But however, if the Upper Tribunal finds that there is a material error of law, then you have to go to the next stage, which is stage 2, and that's called remaking stage. In remaking stage, the Upper Tribunal has two options. Option number 1, it can remake the decision itself, or it can remit the matter back to the first year tribunal for a rehearing if more evidence is required to determine the appeal. If the Upper Tribunal retains the matter to itself, then it can deal with the appeal in 3 different ways. First, it can set aside the determination of the first year tribunal and dismiss the appeal itself for a different reason. Option number 2, it can set aside the determination of the first year tribunal but allow your appeal. And thirdly, as I've already alluded to, is that the Upper Tribunal can remit the matter back to the first year tribunal so that the first year tribunal rehears your case and redetermines it. If the Upper Tribunal dismisses your appeal, then again, against that decision, there is no automatic right to appeal. You will have to seek permission to appeal to the Court of Appeal. There are 2 chances to do so. First, you have to apply to the Upper Tribunal seeking permission to appeal to the Court of Appeal, and for that there is no specified application form. The application can be made on a cover letter sent by either your barrister or your solicitor or your legal representative. Grounds of appeal need to be drafted though for that. If the upper tribunal refuses to grant permission to appeal, which it does in vast majority of cases, then for the second option you can apply directly to the Court of Appeal seeking permission to appeal. That is a complicated procedure in itself, and for that I will have to do a different presentation and will come back to you once again. Till now, that is it, and I'll see you again in different presentation. Until then, take care. Goodbye.